Going into the first topic is SLAPP lawsuits and anti-SLAPP motions. So just as a point of clarity, SLAPP is a noun and not a verb. Has nothing to do with slapping anyone. SLAPP stands for Strategic Lawsuit Against Public Participation. And in English, what that is it's a lawsuit that is intended to interfere with a constitutional right or another protected activity. Something like free speech is typically how we see this come up. An anti-SLAPP motion is a special motion to strike a SLAPP lawsuit. And so what it does is it basically gets the complaint dismissed right away on the basis that it's a frivolous lawsuit. So there are two cases that I'm going to talk about that have to do with anti-SLAPP motions. The first is Daniel v. Waynes. And in this case, an extra who worked on the set of the film Haunted House 2 brought a lawsuit for race harassment against Marlon Wayans, who was the creator, director, and star of the film. So he claimed race harassment. He claimed, among other things, that Wayans made racial derogatory comments, calling him the N-word, and also comparing him to black cartoon characters. In response to the lawsuit, Wayans filed an anti-SLAPP motion. And in the anti-SLAPP motion, he basically argued that this lawsuit went against his constitutional right to free speech because the nature of the film was a raunchy comedy. It was largely improvised in nature, and the sort of core injury-producing conduct arose from the creative process and the creation of the content of the film. The trial court granted the anti-SLAPP motion. On this basis, it found that the conduct went to free speech, and Daniel appealed the decision. And part of the appeal, he said, well, this doesn't really go to the issue of free speech because some of this conduct occurred when the cameras weren't rolling. You know, some of it may have occurred while the cameras were rolling, but some of it didn't. So how is that going to go to the issue of free speech? Well, the California Court of Appeal upheld the trial court decision, and they basically held that the comments contributed to the formulation of dialogue in these largely improvised scenes. To reiterate, and this is what Wayans argued, this is a raunchy comedy. The creation of the comedy was largely improvisational in nature, and it was part of his creative process to make these comments and to joke around on set. So the Court of Appeal upheld the trial court decision, and they also carved out that the creative process can occur while the cameras are rolling and also while they're not rolling. So the takeaway, I think, of this case is that context really matters. So here, this context of an improvised creative process resulted in the court upholding the anti-SLAPP motion. It goes without saying that if this were in a different context, the court might have gone the other way. Like if a supervisor in a factory had said this to a subordinate, probably would have gone the other way.